हेलो एवरीवन, हम 80 WPM पे डिक्टेशन लिखेंगे। डिक्टेशन लिखने के बाद आप इसको ट्रांसक्राइब शुरू करिएगा और जो भी आपकी मिस्टेक्स आती हैं या आपको कोई इसमें डाउट है तो आप मुझे टेलीग्राम पे कनेक्ट कर सकते हो। आप टेलीग्राम ज्वाइन कर सकते हो, हमारा वहाँ पे ग्रुप है। कोई भी आपको गाइडेंस चाहिए तो भी आप मुझे DM कर सकते हो, आपको इसके रिगार्डिंग पूरी हेल्प मिलेगी। So get ready for the dictation. Start. By means of instant second appeal preferred under section 100 Code of Civil Procedure, the defendant appellants in original suit number 391 and two others have assailed the concurrent findings of judgments of both courts below. Stop. The additional civil judge senior division had decreed the suit of the plaintiff respondents in respect of the suit property which is situated at Lucknow. Stop. The learned trial court issued a mandatory injunction to defendant appellant to vacate one half of the western portion of the said house under his occupation, which consists of a room and veranda, kitchen, bathroom on the ground floor and construction raised on the first floor thereof within prescribed period, and hand over the possession of the said portion of the house of the plaintiff number 2. Stop. The learned trial court decreed the suit of the plaintiff void judgment and order dated. Stop. This judgment and decree was assailed by the defendant appellant before the Court of District Judge Lucknow by preferring a civil appeal, that is regular civil appeal. Stop. The civil appeal was decided by Additional District Judge Special Judge Wide Judgment and Order dated 27/7/2018, whereby the civil appeal preferred by the defendant was dismissed and the judgment and decree passed by the learned trial court and decree was affirmed. Stop. Para. This court at the stage of admission of the second appeal framed the following substantial question of law which are extracted below. Stop. Whether the finding recorded by the courts below are tenable in law, as it has held that the prohibition of Benami Property Transaction Act 1988 has retrospective question and the plea is barred under section 4 of the said act without considering the definition of Benami property and Benami transaction contained in section of the aforesaid act. Stop. Whether the judgment and decree passed by the courts below is perverse in law and facts both. Stop. Learned counsel for the defendant appellants submitted that the plaintiff respondent filed a suit for possession and mandatory injunction which was registered as regular suit before the additional civil judge senior division with the averments that the suit is being filed for possession and damages as well as for mandatory injunction, in respect of the house towards western portion of residential part of the house, of which portion of residential part of the house is in the ownership of defendant appellant. Stop. The said land has been purchased in the name of the defendant appellant and plaintiff respondent by his father in order to settle his sons had already. Stop.